glad that you could all come along. We've got quite an interesting talk today from DM Hall, which is very enlightening. So I wish everybody all the best. Hope you have a great day, and I'll pass you back to Ian.
Thanks very much. Cheers, John, and welcome everyone. A massive thank you to Stewart Title for organising this event and sponsoring it, and a massive thank you to you all attending. And I'm delighted to introduce called Callum Armand from DM Hall, who's going to be taking the lead this afternoon. But before we do that, a few things. First of all, this is a sort of a taster. Callum will be sort of producing an in-depth webinar for us on the 30th of June. So do make sure that you've got your booking for that event, which again is sponsored by Stewart Title, but Callum will be sort of leading that. And as far as today is concerned, I've got some topics to talk about: misrepresentation, and also I don't know if you've seen the new guidance from the Law Society on anti-money laundering. I want to go through that before we finish too. But as always with forums such as this, remember, it's your afternoon, it's your valuable hour, and if you have any topics or issues for conversation or things that you'd like raising in the next forum, drop me a note or put something in the chat today, and we'll endeavour to cover that off next time around, as it were. Or if there are burning issues or topics that you'd like to examine today, there is some time set aside for you to do so. So without further ado, what I'd like to do is introduce Callum. Callum, a very good afternoon to you, and thank you for coming along today. I'll take or hand over to you, as it were. Happy to move the slides along for you. Callum, I think what we were saying a little earlier would make sense. If people have sort of detailed questions, today probably isn't the opportunity, but if they send an email in to either myself, yourself, or Stewart Title, you can deal with it in detail in the sort of official webinar that's coming up on the 30th of June. If there are sort of any quick questions that can be fired at you, we could perhaps deal with them at the end of your presentation. But I do think it's sensible, if anyone wants sort of complex issues looking at or exploring, that's dealt with on the 30th of June. So, Callum, anyway, thank you very much for taking of your time today. It's lovely to see you and to have DM Hall along today. So I'm happy to sort of continue to take charge of the slides and move them along for you with your presentation.
Perfect. Right. Well, yeah, thank you very much for that introduction. Yeah, my contact details will be at the end of my slides as well, and I'm sure that they'll be circulated out if you do have any questions, but any detailed questions. So yeah, if you've got anything kind of quick, then we can try and deal with it today. But first of all, yeah, thanks for taking the time out today to join us. A little bit of background about me. So I studied at Napier University, and then I joined DM Hall in 2017, straight out of uni. Later took over the Architectural Services Department in 2021, and later the Energy Services Department. So I've got a team of 6 technicians here and assessors, and we operate all over Scotland. So it says on the slide there that I have a passion for film and an active lifestyle, but in reality, I just go swimming because I eat too much popcorn. So that's enough about me. So we'll go on to property services. So architectural services is just one of the departments that falls under our wider property services department's banner. There's a whole wide range of services that you can take advantage of at DM Hall, and we'll have a quick overview of those now. So we provide a one-stop shop for legal searches and property services, including property inquiry certificates, whole range of legal searching, preparation of deed plans from desktops or site visit instructions, Register of Scotland plans reports ordering, and we also provide commercial energy performance certificates, Section 63 action plans, and display energy certificates, along with a wide range of kind of technical drawing works. But what I'm going to focus on today is alterations reports and statutory consent applications to support the residential housing market across Scotland. So that's going to be our focus for the next few minutes. So I'm going to do things a little bit back to front, and we're going to start talking over some of the key points around building regulations, and then we'll take a deeper look into alterations reports. So the first point to mention about building regulations is that there are 2 schedules in the regulations that detail works that don't need consent. The first is Schedule 1, and that includes all the works that don't need a warrant, and also don't need to comply with the standards at all. So this tends to include things such as works controlled by other legislation, mainly relating to the storage of explosives and nuclear power generation, or alterations to national monuments and crown properties. Also works of civil engineering and large agricultural greenhouses. However, there are some types that are relevant to our work that are contained in the buildings ancillary to houses and buildings ancillary to flats or masonettes, which can include works to erect small porches or conservatories, and also things like single car garages and carports. So subject to certain conditions such as distance from boundaries and the provision of sanitary facilities, which is always a big one in exemptions. Schedule 3 is generally more relevant and has a detailed list of works that can be carried out without a building warrant, but still must comply with the building standards. The first in this list of Schedule 3 is any work in or to a house. That is obviously extremely broad, and there are exceptions to these exemptions. So if we look at the next slide, we'll say these exceptions include increases to the floor area of the house, works affecting an external wall or an element of structure, works affecting a separating wall or floor, and any works carried out to a house with generally 3 or more stories. There are similar exemptions in private non-residential commercial buildings such as offices, although in this case the floor height is increased to 4.7 meters, which is very difficult to say how many stories that is because commercial buildings vary so much more than residentials. It's worth noting that we are past the date of the 1st of May 2025, and you might be wondering, why is that important? So the 1st of May 2025 marks 20 years since the date that these regulations came into force. That means that going forward, it would be very rare to encounter a scenario where the previous regulations would require to be considered. Works will either be subject to the current regulations and therefore either require consent or be exempt under those regulations, or be historic in the context of the Scottish standard clauses. This is where our reports can really assist. They will provide clarity on which route you might find yourself having to address. But before we move on to the reports, I want to run through a kind of quick worked example of something that you might come across in a transaction. So if we look at the next slide, so let's imagine for a moment that we have a 2-story house, and it's been noted in a home report or another survey that a wet floor shower has been installed in an ensuite. So the wet floor shower example is an interesting one because it almost falls between the cracks of the building warrant exemption schedules. It's a point that I would always advise having looked at. So we offer 3 report types, and they're based on the 3 consent types, building warrants, planning permission, list building consent. So we're not going to go into massive amount of detail here on when and where various permission types might apply, but instead focus on building warrants and the technical standards. So in order to properly resolve an issue, it's issue to identify the works that have been carried out, determine if they required a building warrant, and finally determine what, if any, remedial works may be required to bring those works up to current standards. So we look at our wet floor shower example. There's a provision in the building regulations, Schedule 3, that allows this installation of a sanitary facility without the need for a warrant in either the flat or a house. However, the footnotes of the regulation make it clear that a wet floor shower is not covered by this provision. So you would think that that means it needs a warrant. Well, actually, no, not in this specific case, because if we go back to the beginning, we're dealing with a 2-story house. And as discussed, since that date in 2005, you've been able to carry out much more works to a house without the need for a warrant than you previously did under the previous regulations, or that you can currently carry out to other property types, such as 3-story houses and flats. So we can therefore state that in this specific scenario, the works are exempted for the requirement for a warrant and the transaction can continue. Now, one thing that we've not discussed here is any compliance with technical regulations, but that would depend on exactly how it had been done and whether it had been done to standard. So if we move on to alterations reports, we're now all experts in the Building Scotland Regulations 2004. So we can shift our focus on what we do with them and the alterations report service that we offer. So if we look at the next slide, we can look at the format of our report. It's broken down over 3 sections. In essence, what work has been done, what permission did you need, and is there anything wrong with the work? So section 1 will typically be based upon an alteration picked up in a home report or a property questionnaire completed by the homeowner. We don't identify alterations. We report specifically over what we are told has occurred. Where an alteration is identified and no paperwork is presented in terms of letters of comfort or warrants or completion certificates, our reports can assist. So in section 2, we will then go on to talk about the impact of the building regulations, the town and county planning regulations, or the relevant listed building consent policies, depending upon the scope of the original instruction and the status of the property in terms of its historic importance. It's in this section that we will confirm if the works are historic, if they are exempt, or if they should have sought consent. In this scenario, we'll also provide outline costs to obtain the consents in retrospect and explain the process of how we go about gathering those consents. In the final section, we will review the work's compliance with the relevant standards and outline if we believe any remedial works may be required, or if there are any outstanding items of documentation, such as an electrical safety certificate. Our inspections are non-disruptive, and standard assumptions are going to be made about concealed elements. We could continue to talk about the Building Scotland Act 2003 and its implications, go through all the possible exemption scenarios, how an application is made, and what the costs are. And if you're interested in that, then you can join us at the end of June. Or if you send me an email with a question, I'll either get back to you with an answer or it will be included in that presentation. So on the next slide, we've just given a quick example of what our reports look like. So each section is clearly laid out so you can easily identify each part, and it provides contact details at the bottom so you can follow up with any queries you or your clients might have. The one on the sample on the screen is to do with a Velux window being installed, and we've picked up a number of items there that might require being looked at. So before we come to a close of my bit and we move on with the forum, just wanted to highlight the national coverage that we offer at DM Hall and specifically in the Architectural Services Department. So we've got a wide range of offices. We have technicians based not in every office, but we across the full spread of Scotland. So all of our property services are provided across Scotland and certain services also into Northern England. We have a dedicated and widespread team who are happy to help your client wherever they are. And although we're focused in Fife and the Central Belt, we can service clients across the borders and into the Highlands and Islands of Scotland if you're lucky to have a client up there. So that's pretty much everything from me. As I said, if you do have any quick questions, I'll do my best to answer them. But otherwise, my contact details should be on the next slide, and we can follow up at a later date. So thanks for your time.
Thanks, Callum. Callum, just a couple of questions from me. As far as your alteration report is concerned, I mean, roughly, obviously, it depends on the task and depends where it is, but what sort of time frame for instruction to return?
Yeah, absolutely. So we're conscious that the alterations are normally picked up towards the end of a transaction. It's often a last minute thing. So we aim for a maximum 7-day turnaround for these reports. So what we say is we try and get out to the property within 5 days of instruction, and then the report available within a further 2. To be honest, we're normally turning these reports around within 3 or 4 days. Sooner if there's a real time pressure, but no more than 7 working days is our standard turnaround.
Yeah. And standard fee or charge per matter, or how does that work, Callum?
So it will be feed based on the scope of works that we need to look at. So there's a minimum fee based on looking at one issue for one consent type, and then for each additional piece of work that's been carried out, and for each additional consent type that needs to be looked at, we would charge a surplus on top of that. So so for example, if you were looking at an attic conversion and a set of patio doors, that's 2 issues. If you then wanted us to look at building warrant and planning permission, we'd be looking at, instead of 2 issues, you've now got 4 things to look at, because you're looking at both consents for both things.
Got you. All right. Thanks, Callum. That's brilliant. So I'm really looking forward to the thing on the 30th of June. I know it's a major issue for practitioners, and the fact that, you and your team are available to provide assistance and react so quickly is fantastic. Does anyone have any comments or any issues? Just put them in the chat now rather than the Q&A. I just find the chat a lot easier to deal with rather than Q&A. But if you have anything, feel free to drop a note in there. And Callum, what I'll do is obviously liaise with you before the 30th of June, but it really would be good if people have specific or detailed questions. If you can let Callum know beforehand, then I'm sure he can incorporate a response that answers the question on the next occasion. Thanks so much for your time today, Callum. It really is appreciated. I know DM Hall, a nice organisation, a good organisation, and I was interested to see your sort of nationwide spread there, as you say, covering the central belt, but getting up northeast and able to cover highlands and islands if necessary. So great. Last question, Callum. Are you the sort of focal point for this, or do people contact the local office if they are local, or how does that work?
Yeah, so I mean, if you've had a DM Hall home report carried out, and that's where the alteration was picked up, your first port of call might be the home report surveyor who did that, or the local office. But any alteration query that comes into any avenue of DM Hall will ultimately get routed to me. So now you have my contact details. You can come straight to me if that's easier. But yeah, ultimately, you can contact anywhere in DM Hall, and it will find its way back to me. Brilliant.
All right. Thanks, Callum. That's great. We'll look forward to catching up with you on the 30th of June. Thanks for your time. Are you sticking around, or are you?
Yeah, I think I'll stick around. So if anything does come up, I'll be here. But I hope to see everyone on the 30th.
Fantastic. Thanks very much. Good.
Right.
So that was really enlightening, and I'm looking forward to hearing a bit more from Callum about the sort of a deep dive into the reports, etc., on the next occasion. Anyway, what do I want to talk about today? I would like to talk about, first of all, some misrepresentation in Scottish conveyancing. I've been looking at a case at some length last week and over the weekend that I want to share with you. And I also want to touch the new money laundering guidance. I don't know if you've seen that, issued, I think, on the 23rd of April by the Law Society. And again, I want to have a bit of a deep dive into that, to be honest with you, because I think it's so important. Anyway, I'm just going to pull up the case that I was looking at over the weekend and just want to share with you that one. This was a case called Anwar against Britain and Barclay, I think it was. And it was a misrepresentation case. Sheriff Appeal Court decision looking at the standard clauses, clause 27, and whether or not it precluded a claim for misrepresentation being brought. Don't know if you've read this case, but it was a case concerning flooding. And it was a situation where the buyer of the site was very concerned about flood risk. Search undertaken that revealed there was a low risk of flooding, and the buyer really wanted to have an investigation as to what low risk actually meant. So raised questions relating to the potential defenders in the proceedings concerning their knowledge relating to flooding. And the position was that the response was provided that the sellers weren't aware of flooding risk, property purchased, and during that purchase process, the buyers became aware that there was a significant risk of flooding and that the defendants were aware of that flooding occurring in the past. They were also aware of the buyer's intention to develop the property and therefore understood that flooding or flood risk relating to the property would be significant. So the details, on 24th of May 2016, a formal written offer to purchase was submitted on behalf of the pursuers, incorporating standard clauses, conditional amongst other things on a flood risk report in satisfactory terms being obtained. I always worry when people start talking about, flood risk report in satisfactory terms being obtained. What does that actually mean? I'm always worried about conditional offers, or indeed anything that's conditional, where it's impossible to ascertain just what the condition is. So I've seen cases in the past where, the idea of satisfactory terms has been tested by the court, and the courts have sort of verified that, in essence, loose or vague or ambiguous conditions are unenforceable, meaning that you've got an unconditional position. But we'll park that for the moment or two. That wasn't tested before the courts. The pursuers in the case were of the view that the issue of flooding was important to them. They made the defendant aware of their intentions regarding development of the property. Another really important and practical point: whenever you're acting for anyone purchasing a property, it's always worth disclosing to the seller what your client's intentions are. Of course, provided that that doesn't generate any form of vulnerability relating to the transaction on behalf of the buyer. But anyway, as I mentioned, flood risk report was obtained, classified the risk of flooding as low, but recommended that the pursuers speak to the sellers to confirm whether the property or surrounding area had flooded. So the position was that an email was sent, and by email dated 14th of July 2016, the defenders' solicitors confirmed the defenders had no experience of flooding at the subject, and the missives were then concluded on the 3rd of August 2016. The pursuer buyers claim they discovered in November 2015 the stream which passed through the property had overflowed, and the first defender at least was aware of flooding in the garden from time to time. So you had the sort of standard misrepresentation position, question asked, response provided. Buyer then contends that the question wasn't answered correctly, and a potential for misrepresentation flows from that. A few things, of course, with regard to misrepresentation, there has to be inducement. There's been one or two interesting cases in England on this very topic as to what is the position if you've had, for example, a survey, or you've had a report that reveals a risk or an issue, and yet the seller has said in a reply to a question that there isn't a risk or issue. Do you rely on what the seller says, and does that induce you to enter into the contract, or ought you to rely on what the professional surveyor is saying, or on what the report is providing? Now, there's two or three things that flow from that, really, in my view. One, English courts seem to be saying it doesn't matter that information is generated to you from a variety of different sources, as long as the seller has advised you of something that isn't correct. The fact that you've got the same information from alternative sources, no matter what those sources are, doesn't matter. As long as you can say that what the seller said induced you, it doesn't matter what the extent of the inducement was. Again, that wasn't an issue that was determined in this case, but it's a point that I think is worth examining. Some people argue that, sort of caveat emptor applies, and therefore what the seller says is an irrelevance, and misrepresentation is highly unlikely to flow as a consequence of a statement proving to be false. Anyway, the matter went for trial in Falkirk, and what the sheriff decided was that clause 27 of standard clauses didn't exclude reliance on a misrepresentation which predated the contract, and therefore the email of the 14th of July 2015 was relevant, and second, that clause 213 of the standard clauses should be read as warranting the property hasn't been affected by flooding from any river or watercourse which has taken place within the last 5 years. So the court basically was saying we're of the view that there's been a misrepresentation here. The matter went on appeal, and the position was that the sheriff's decision was upheld by the court on appeal. The court found, with regard to clause 27, that the email of the 14th of July 2016, predating the conclusion of missives, basically meant that the natural meaning of the words in clause 27 wouldn't preclude a misrepresentation claim from flowing. And the sheriff principal in the case said, reading the clause as a whole, it appears to be conveying one message rather than two, as signified by the absence of a comma or other separator between the opening phrase. So what he's saying there is, one, you look at this and state that, in essence, the condition does not sort of eliminate risk or liability with regard to previous statements. And second, the sheriff principal said, the natural and ordinary meaning of the words used is not that the parties are giving up the right to rely on any misrepresentation which may have been made. So really interesting case. Has anyone seen it? Has anyone seen any other misrepresentation claims? Has anyone had the requirement to bring proceedings for misrepresentation in the past? Can I just say that I think there's a very important point to make before we go any further with regard to misrep, and that is this. It's all well and good as a conveyancer indicating to a buyer who is a potential pursuer that they can sue the seller for misrepresentation. The key feature is, will the pursuer or potential pursuer have an appetite to do so, given the amount of cost that could be incurred in connection with the bringing of a claim and given the risk associated with it. Again, in England over the last sort of 2 years, there's been a number of sort of high-profile misrepresentation cases, one just recently involving an infestation of moths in a high-value property in London. And again, the legal bill in that case exceeded £1 million. All right, yes, it was a high-value property. Yes, it was in central London. But even a relatively low-value case in the courts concerning a relatively sort of standard transaction in the sort of central belt of Scotland or wherever could lead to some significant costs being expended with regard to bringing the claim and severe risk with regard to the other side's costs in connection with losing the claim, as well as misrepresentation being a notoriously difficult type of claim to stick due to the point of the inducement that I mentioned a little earlier, as well as the application of the standard conditions which were explored in this case. So again, just our answer to the room, answer to everyone attending today, anyone had a misrepresentation claim or the potential for a misrepresentation claim? My guess is a number of potential defenders will settle rather than risk litigation, because just as I've mentioned, there's a litigation risk for the buyer, there's just the same risk with regard to the seller. And the other thing that's interesting is, and again, this arises from the English cases that I've been looking at, where a seller has been successfully sued for misrepresentation, I wonder to what extent the seller has then looked to their solicitor or conveyancer for a claim in negligence. And again, I think the point there is, to what extent is the solicitor or conveyancer for the seller participating in the decision-making processes where questions are being asked of the seller during the conveyancing process. In the moth case that I was telling you about a little earlier, the seller asked their solicitors, what do these questions mean and how do I answer them? So I don't know yet, but my guess is that the seller solicitors will be on the hook for a negligence claim, given that the buyer successfully sued the sellers for fraudulent misrepresentation with regard to defective replies to questions. In that particular case, just by way of background, the seller was asked, are you aware of any vermin at the property? And are you aware of any infestations at the property? And the seller's solicitors, looking in the dictionary, said, well, moths aren't vermin. And again, looked at the definition of infestation, which, and, you know, a reference to sort of mice and rats. And again, the conclusion was, well, moths aren't an infestation either. And what the court said, well, there's no, you know, any reasonable person looking at a question about, is this property infested with vermin, or is this probably subject to any form of infestation, given the amount of clothes moths that were at the property and the problems were causing, the seller should have, if there was any doubt about whether the information was caught by the questions, have volunteered the information anyway. And I think that's another interesting point with regard to misrepresentation in both Scotland and England, you know, where questions are asked that are wide-ranging, then they warrant a wide-ranging response. Okay, well, no one sort of commented on that in the forum, so that's fine. What I want to do now is talk about the new money laundering guidance. And the first thing to ask is, you've all seen it's on the Law Society website. And there's a number of things that are new in the guidance. First of all, overseas entities, registration of overseas entities, of course, which was or has been law in Scotland far longer than it has been in England, but the need to observe caution where transactions involve overseas entities. And the other thing that's really interesting that was got my attention when I was looking at it last week was this idea about establishing sources of funds and sources of wealth. And there's a few important points really to explain, and we've touched on this in a previous forum, but again, it's worth repeating given the sort of change or amount of emphasis that's in the new guidance. As far as sources of funds are concerned, this pertains directly to funds that are being used to fund a transaction. So the origin of funds used for the transaction, ascertaining where the funds came from and how they were accumulated by the client, and on a risk-based approach, ensuring they're not the proceeds of crime. So what you're doing there is you're looking at bank statements, you're looking at information that perhaps would be an indicator of the original source of funds, wills, accounts showing funds disbursed to the client, sale purchase agreements, etc., documentation relating to savings accounts and the like. And again, the important point here is the extent to which you investigate depends on the level of risk that you attach to the client and indeed to the transaction. And again, one of the things that the new guidance emphasizes is that you've got to be cautious that accepting payments for an unknown or unassociated third party is a specific risk factor. Well, I'm sure no one would be willing to act where funds are coming from an unknown third party. But what about an unassociated third party? Well, again, that is now regarded as a specific risk factor. So where we've got someone that has no connection to our client providing funds, you now have to appreciate that that is a specific risk factor that is highlighted in the guidance. The other thing that's interesting with regard to sources of funds is to make sure that we are identifying the amount of funds that are being received, the currency in which it's being received, and remitting account details. Information obtained should be substantive and establish a provenance or reason for having been acquired. Again, in circumstances where it becomes known a third party is to contribute funds, you should consider seeking to understand and obtain evidence from them as to their source of funds. That's something that I think is often overlooked or seen sort of as an afterthought. I think when you're onboarding a client, it's worth mentioning to the client right at the start that where third-party funds are being utilized in connection with the transaction, that it will be necessary for you to chase the money and to make inquiry of the third party relating to the information that's necessary. That would enable your buyer client to put the third party on notice that A, you're going to be contacting them, and B, that you're going to be requesting information, and the third party and your client should understand the reasons why. One of the things that's emphasized in the guidance, new guidance, need for an extensive source of funds check should be informed by your ongoing assessment of client and matter risk. So again, it's something that needs to be taken into account at the start and then also checked as the transaction progresses. The next thing to talk about are sources of wealth and source of wealth checks. And again, as far as this is concerned, it would be necessary where you require enhanced due diligence or where a transaction is high risk or the client is high risk. And a source of wealth refers to the origin of a client's entire body of wealth. And this involves a sort of wider look at the client. So the economic, business, and/or commercial activities that generated or significantly contributed to the client's overall net worth. And this should recognize the composition of wealth generating activities and the fact that those activities can change over time, and should look at activities that are undertaken by the client and the accumulation of wealth arising. So again, the interesting point here is that in the new guidance, it's described as a holistic appraisal as to where an individual or an entity has derived their overall wealth rather than any specific portion of it. In low, medium risk transactions, you could be comfortable identifying sources of wealth by asking and recording how the client has accrued their wealth, or by verifying client's business interests through searches. And again, for corporate clients, you could be comfortable that an intended transaction is consistent with what you know about the company, rather than having to do any further. But there are now in-depth guidance on sources of wealth and sources of funds within the guidance itself. And when we talk about enhanced due diligence, again, it's important that we appreciate that a source of wealth investigation would be appropriate for clients. So, question to everyone attending today: have you all read the guidance? All appreciate the sort of subtle changes relating to the guidance, and also putting that guidance into practice? Okay. Remember, with regard to risk assessing, you're risk assessing the client and you're risk assessing the transaction. You're doing that on the onset of instructions, but you're also reviewing risk as the transaction progresses. Remember, with enhanced due diligence, you've really got to be concerned about the beneficial owners of asset as well as legal owners of asset. And again, with regard to enhanced due diligence, it's important that you investigate a greater level of information and explanation from the client, and that you perform greater frequency of checks on transactions, and that you undertake more frequent due diligence checks on the client. Again, the guidance is highlighting the fact that more work has to be done by way of monitoring rather than just assessing risk at the start of the transaction. Remember, enhanced due diligence needed for high-risk countries. And again, it's important that you monitor what are high-risk countries. It's also important, I'm just clicking through the situation, that you also look at the parties to the transaction, the client, of course, other parties to the transaction and their advisors. So when we're dealing with enhanced due diligence, we're not just looking at the transaction and our client, but we're looking at third parties involved in the transaction as well. Again, important that you revise, or at least provide evidence of consideration of whether it's not necessary to revise your risk assessments. Has everyone done that? So if you've looked at the new guidance, have you amended your policies where appropriate, or at the very least indicated that policies do not require amendment, notwithstanding consideration of the guidance? One of the things I think is really important with regard to AML is that if we have policies, those policies are kept under review. For example, if there's new guidance issued, or National Crime Agency, or indeed or Law Society of Scotland or professional body indicates sort of further red flags or other steps or measures to be taken, that consideration has been given with regards to whatever has been asked of you, and that policies or practices changed as a consequence, and that staff are aware of those changes. I think all of those things are really important. Anyone had any issues with politically exposed persons? Someone was just asking me last week about someone that was a sort of county councillor or a local councillor, and someone was asking me about a client whose spouse was a county councillor. Are they politically exposed persons? Well, if we look at the list of politically exposed persons, which I've just got here, heads of state, heads of government, ministers and deputy or assistant ministers, sort of MEPs, members of parliament, etc., members of governing bodies of political parties, members of courts or constitutional courts or any judicial body, members of courts of auditors or boards of central banks, ambassadors, charge d'affaires, high-ranking officers in the armed forces, members of the administrative, management or supervisory bodies of state-owned enterprises, directors, deputy directors, etc., of any one of international organizations, family members of a PEP, spouse, civil partner, child, spouse or partners, and parents. So what would your view be if you had a client that was, say, a county councillor or a district councillor? Would they be politically exposed or not? Well, they're not necessarily on the list, But what I would say is, do they hold a truly prominent position with regards to local government, civil service, or military? I think really that's the test that is required. And remember, it's spouse or spouses and or family members as well. Okay, right. So identification of PEPs involves a risk-based approach. And to do that, you ask yourself, what role does the individual that we're challenging hold? What's the nature and context of business relationship? What services or products does the politically exposed person wish to use? What's the potential for the product to be misused? Do you know if they have close family members or known associates? What roles do they hold? What level of public scrutiny, exposure, governance is their role subject to? All of these things need to be carefully looked at. Charlotte, hi Charlotte. Yeah, I think that's a point. So their local councillor position, Charlotte, wouldn't be enough. Yeah. But known political party membership and the extra exposure. To be honest, Charlotte, I think if in doubt, regard them as a politically exposed person would be my test. But I agree with you. You know, you've done a risk assessment. You've looked not only at their status as a councillor, but also what else they're doing. And you've probably answered those questions. What role does he hold? What is the nature and extent of their business relationship with you? What's the potential for the product to be misused? So the conveyancing, I think, is sort of high risk from this perspective. Is there a risk of corruption, etc.? Well, the answer to that is yes. So fine, yeah, local councillor, probably not sufficient to say PEP, but any sort of additional political role potentially would have that consequence. And remember, it's not just politicians that are vulnerable, as I repeat, the judiciary and also military, senior management, really. What about simplified due diligence? Again, lowest permissible form of due diligence under the AML guidance. A low risk of money laundering or terrorist financing. Do you think any conveyancing client will be low risk? Or do you think because of the risk associated with conveyancing, that immediately increases the stature of risk? So what's everyone's view with regard to that? Do you say, well, conveyancing is high risk as an activity, and therefore a conveyancing client is never low risk? Or do you think that's too simple and too much of a broad brush approach? Yeah, I think that's right, Diane. I think they're always going to be medium to high risk clients, not because of the client, but because of the activity. That has to be the point, doesn't it? So I agree with you. And as far as medium to high risk clients are concerned, that requires monitoring, ongoing monitoring with regard to the transaction. Speaking to someone last week on this one, Diane and Charlotte, once you've onboarded the client, are there stages in the transaction where your case management system or where your firm undertakes another risk assessment? So, for example, if you're acting for a buyer and we're about to request funds in connection with the purchase, would you undertake a further risk assessment at that juncture? Or any stages in the conveyancing process where, as a standard, you'll review? Remember that there may be factors that are drawn to your attention during the life of the transaction that mean that what was a low risk or medium risk client all of a sudden becomes high risk. So I started talking to someone over the weekend, and they were sort of funding a purchase. I mean, to what extent it was true or not, I don't know, but we were talking about selling gold bullion and releasing some cryptocurrency and all sorts of things to facilitate the purchase. And I was sort of sitting there thinking, well, all of that has the potential to cause all sorts of problems. Yeah, you continue to monitor transactions. So, Diane, you don't have a sort of set point during the transaction that you will do a sort of formal assessment on file. So, Cheryl, I think what you're saying there is you have interim assessments during the process. So there are regular triggers during the process, which I think is fine. And then any change to profile or finance of client, again, would trigger an assessment. So if I'm your client, Cheryl, and I'm saying, right, I'm funding this purchase from the sale of another purchase, but then my sale of my existing property is the purchase price is reduced due to a problem of valuation or whatever it may be, or survey, and therefore I'm introducing funds to facilitate my purchase. Of course, that situation would trigger a further assessment, wouldn't it? Because it might be that I'm going to have to use savings. I'm going to have to get some form of funding elsewhere, either from friends or family, or from another institution. Yeah, it's that sort of thing, isn't it? And then I think at the conclusion of a file, would anyone sort of review what they've done with regard to risk? And with a high risk transaction, and we've just said that, you know, conveyancing transactions are likely to fall into the higher risk category. What about reviews? So do you, as a matter of policy, have someone undertaking a file review and a risk review with regard to AML? And Diane, I've got that. Yeah. Okay. And Diana, yeah, I get that. Yeah. Okay. So I do think it's important. Remember, with regard to money laundering and with regard to disclosures, etc., we're not disclosing criminal activity. We're disclosing, or obliged to disclose, where there's suspicious activity, aren't we? So again, you know, there could be little drips of bit information that of themselves are not suspicious activity, but cumulatively they are, or there could be sort of red flags that we become aware of during the transaction. Either way, we've got to be alive to it. I mean, I don't know what you've seen, but some of the fines that are being imposed on firms with regard to non-compliance with AML are absolutely astounding. You know, you're not talking about a slap on the wrist. You're talking about sort of transformational fines, you know, putting people out of business potentially. So it really is scary. And I think it's so unfair, to be honest, because, you know, at the end of the day, we're not actually perpetrating the fraud. We're simply, I suppose you could argue at its worst, facilitating it. But we're not generating any financial benefit, and we're not directly involved. We're just not asking the right questions, or not assessing or complying with policies. And again, you know, someone was talking to me last week about it and was sort of terrified. And I was saying, well, you know, again, it's just a question of doing a very simple thing, really. Looking at the transaction at the start, looking at our policies and procedures, and looking at where this transaction, where this client fits with regard to risk assessment, making sure that when we're assessing risk, we show on our file or our case management system how we formulated the risk. So in other words, you know, this client is new to us. This client doesn't have a sort of social media profile. This client is in a high risk business activity. You know, they own a barber's or a hairdresser's, has a lot of cash, or something of that nature. Or what else did I see recently? Someone that was a fairground operator. You know, again, handling a lot of cash. You know, immediately wrong to suggest it, but handling lots of amounts of cash, high risk. The client that's you know, investing in gold bullion. Well, would a client of that type, with that sort of investment, invest in gold bullion? You know, is that consistent with their sort of own circumstances? You know, really, we're touching on sort of sources of wealth there, aren't we? Which I think is the issue. But I do think it's difficult. But I think all you can do is have policies, make sure those policies are reviewed, and make sure that as FIAN, as we're complying with those policies, make sure that where we're not sure, we're asking, questioning, challenging, and that we are making sure that where reviews are necessary, that reviews are undertaken. And I think the other thing is, on the file, show how we've reached the decision. So it's not just a tick box exercise, but it's an actual, you know, that's what we know. That's the decision that we've made. Stewart, hi, Stewart. Great. Yeah, I don't know. How are people dealing with overseas clients? Again, last week I had someone asking me about someone that was a Greek national that had opened up a UK bank account, but the Greek national's address was in Athens, and that in opening a bank account had given an address in the UK that wasn't their home. So again, immediately that was suspicious. So again, Stuart raises the question, anyone, Cheryl, Diane, anybody else, how have we dealt with funds from overseas? Susan, that's a really interesting question. I think there are firms out there doing this. And Charlotte's saying, there, Stuart, we ask for translated documents, bank statements, etc. And again, that's a good point, Charlotte, but I'd be wary about who's done the translating. Are you with me? Where, where the client sort of volunteers, well, here we are, my wife or my partner or whatever has translated it for you. I'd be wary of that. So, Susan, I'm going to make inquiry about that and get back to you, but I'm sure there are companies that will provide that service. Yeah, and anyone else help with Stuart? Thanks for that, by the way, Charlotte. Yeah. I mean, how far do you go, right? How far do you go? So someone produces a translated document of a bank statement or will or an asset sale or something of that nature. Just what do you do? Who has produced it? Do you have to then contact them to say, have you produced this document, etc.? Yeah, I agree, Susan. Yeah. Analytics, yeah. All right. And Farah, was that a source of funds report that had international connections? Or was it just an analytics report from a source of funds in the UK? I know Analytics, by the way, so I can get them to come along, and I'll try. We'll get someone certainly to come along. Yeah, I mean, it can't be uncommon, can it, for international funds to come in? Yeah, Cheryl. Yeah, definitely. I mean, that's your source of wealth idea, isn't it? And it's just common sense, isn't it, really? And it's asking, it's part of the sort of know your client, which I think is what the Law Society and other professional bodies have asked conveyancers to do. Yes, Stuart, I remember in the good old days where, I would have clients coming in where English was the second language, and they'd have children in or next door neighbors in, or, someone that worked with them that would translate. And I look back and shudder, because how on earth? I mean, what I would do is I would always start by telling them something and ask them to translate it, and then ask them to translate it back, so I could at least check whether what they were saying was a sort of, in essence, a mirror of what I'd said to them. But beyond that, what would you do? These days, I agree, Stuart, yeah, official translations, but they are really expensive. And again, are you then verifying the person that's produced the official translation? And I think that's the other thing with all of this, the client is paying for it, isn't it? So the client needs to know about the fact that we're not being pedantic, that we need this, and it's sort of compulsory. And no matter where they go, whoever they instruct, we're all asking the same thing. So, there isn't this sort of cheap or easy option. All right, so I think we'll have a look at analytics and we'll investigate Susan's point there. Has anyone else got any other topics? What's business like at the moment? Are you finding that there's plenty of business out there? All this sort of turmoil that we've had with regard to the economy, etc. I don't think it's sort of dampened the market, has it? Or do you think it has? And I appreciate in Scotland, you have different hotbeds of sort of activity and area, but from what I can gather, sort of across the board, I think people are still busy. I don't know what high end is like in Edinburgh, or high end is like, with regard to agricultural estates or high value sort of properties, trophy assets, as it were, down the countryside. I don't know what they're like, but certainly as far as the market generally is concerned, I think people seem to be saying it's still fairly buoyant. Don't know what anyone else is thinking. Yeah, very buoyant, Kay. Yeah, I think so. Right. Stewart, Third Fort. Yeah, I know them as well. Amicus both access open banking. I think those funding. Right. Yeah, no Third Fort too. Well, we'll do something so we get that looked at for next time. And I'll talk to Miller and Bryce as well. Any other topics then? Any other issues? How's our friends at the land registry doing at the moment? Are they all right? Are they our friends, or are there any issues with delays? I'm going to get the Quayle Authority along at some point to talk to us, probably later in the year. And of course, we've got our conference, which I think now is sometime in September, where we've got some interesting speakers for that. But we've got 3 minutes. Anyone got any further questions, any issues to talk about, any problems to talk about? Do drop us a note so we can get you on the list for the conference, email address shown on there. Do drop me a note if you have any questions or queries in connection with our next forum. And of course, if you have any queries for Callum, that would be brilliant. Ping them to me or to him or to Stewart's Title. Do be aware that John and Liz from Stewart Title are always on the road, always happy to talk to practitioners about title indemnity insurance. Remember that as far as title indemnity insurance is concerned, there are compliance issues and firms do need training, regular training. So if you've got new members of staff, do talk to Liz and talk to John, because I'm sure Stewart Title can provide training relating to compliance issues. And also have a look. I'll just go back to the slides because I skipped over them right at the very beginning. I'll just go back and show you that Stewart Title have an online presence that enables them to provide assistance and guidance to practitioners. Just show you this one. And also they're able to provide bespoke policies. So do be aware of John and Liz's contact details. Liz is on there, as is Robert Kelly from Stewart Title. And as we're getting towards the close of today, thank you so much for coming along. I hope you've enjoyed it. I hope it's been of use. Callum was brilliant. I look forward to talking to Callum again on the 30th of June. Lots of stuff on AML. Please, please, please have a look at that guidance. Make sure that if nothing else, when you've considered the guidance, you've reviewed your policies and there's a note to confirm they've been reviewed. I think that is so important, okay? And again, if you're changing policies, make sure that Fiona is aware of it too. Thank you for your kind words, by the way. It was really interesting. Topics for next time, just ping them across and we'll have a look. Nice to see you, Jenny. Thanks for that. And thank you, everyone. Great, okay, brilliant. Well, look, to be honest, I really enjoy it. And something else, our Scottish forums are always better than the other forums we do throughout the United Kingdom. And the reason is we get really interesting speakers and we get good attendance from people who are willing to participate. So never mind thanking me and thanking Stewart Title. Massive thank you to you for coming along. And again, it's your forum. Fire away with questions at any time and we'll deal with them. Thanks, everyone. Speak soon. Have a lovely day. Enjoy the sunshine. Thanks. Bye-bye.